So again, to introduce myself again. My name is Abhishek, and I'm pursuing my PhD from University of Hamburg, and I have had little experience of teaching and working in law firm, and my area of interest involves the parallels study between constitutional laws and the international law as a system and constitutional law as a system. So more theory, then also international law in general. But in this project that I'm going to talk with all of you, I'm trying to see the interplay between international law and whether it is really strengthening the cause of constitutional laws or municipal laws, or in fact they are going in two different directions, producing counterproductive results, which needs to be further synchronized through rules. So there is what we call. Do I start with the main topic now? Okay. So after that, the topic that I'm going to present today involves about the conceptual problem that a federal state faces while dealing with the issues pertaining to armed conflict. In this case, protracted armed conflict. Why protracted armed conflict? Because over the period of time, the concept of armed conflict has the concept of armed conflict has really reduced to the conflicts which involves more non-state actors, either through agency or property of the state players, or through dissident forces acting within the territory of a state. So all I'm going to see is that how first that international law has dealt with the concept of protracted armed conflict in the light of the ICTY cases. And then I will see that how Indian constitution has responded to it in two-pronged manner. First, the constitutional response to the problem of armed conflict, and second, the statutory reforms or statutory response to the armed conflict provision, and see that whether there is repugnancy or conflict between the statutory and constitutional norm, or statutory and statutory norm between federal and state bodies per se. So let's start with my first slide.
You sure it's working? It's complete.
Okay. So since it's my project, this can't go. Okay. Thank you. So as you see, the starting point is peace and war blooding. If we try to understand the concept of a constitutional state, which is basically a nation state, is a result of the theories propounded by authors such as Kant and Rousseau and so on and so forth. For example, if we read Perpetual Peace by Kant, he mooted the idea of nation state basically in order to constitute a peaceful society, which he calls a perpetual peace. And therefore, for that, he suggests a system of a society which is basically a nation, and then it must have a constitution in order to legitimize the powers, public powers, who is going to recognize that, and that's will ensure peace, because the question of invasion or usurpation of territories and so many other questions would be put to halt. Plus, the choice of government given to the people will also give people a kind of veto if the state wants to go to a war, and it has to take the permission from the state. So this is the basic backdrop why we have a constitutional societies for peace. Over the period of time, the constitutional society, in my understanding, has in fact become the sole reason for having more and more non-peace situation. Another development that has taken place in international plan, because if we read again the Rousseau or Kant, they suggested international law as a body of these constitutional societies coming together, creating a federation. That's why they call it initially law of nations instead of international law, which is basically a Benthamian concept. So the law of nation was basically these European nation states coming together form a society which will protect these internal peace from the outside attacks or outside of infiltration in their domestic understanding of the self-governance. With this, alongside this, we saw over the period of time that international law became more and more assertive. It became more and more prescriptive from earlier being descriptive. What I mean by being prescriptive than earlier being descriptive is that you will see that in the general international law, it will recognize that there is a law for how should war be conducted and all that. But if the war is conducted between two states, it will not guarantee the survival of the one state. If the other states dies in that process, the international law was fine for that, fine with that. Over the period of time, this descriptive nature of international law was largely changed, and the heralding point of which could be said to be a United Nations Charter or its earlier avatar in form of League of Nations, which is nothing but United Nations Charter 1.0. So why I did this study, because I was very confused while understanding the concept of what exactly do we mean by war. When I read the various authors and even the, in my opinion, one of the finest scholars on this issue, Yoram Danstein, has argued that the architecture of world order and international peace and security system initiated by United Nations Charter has in fact given way to the demise of what we call the state of war. It has taken from just ad bellum to just contra bellum. Just ad bellum, where the states had reasons to justify, for example, the national theory of St. Augustine and others, that you can go to a war provided there is a just cause, such as religious persecution by it in a territory and XYZ. So this was the reason that war could have been fought, but just contra bellum was initiated by, if you want to know, it started by the Kellogg-Briand, but institutionalized by the United Nations Charter in form of Article 2 Clause 4, which put a blanket ban on any kind of use of force in international relations between the states. It also prohibited the institutional non-intervention in the form of 2 Clause 7, where it says that even the United Nations cannot force the states to surrender what it considers the domestic matters to the international system that was heralded by United Nations Charter. So the point was that the concept of war was fading away, and the new concept of armed conflicts was replacing itself very swiftly. In addition to that, when I come from India and I see a conflict in my country perpetually ever since the modern constitutional society of India came to existence, very much like Israel. We have been invaded, and after that, the invasion took shape of what we call the asymmetrical warfare, or sometimes it is called protracted armed conflict, or sometimes it may be called as low-intensity armed conflict. You name it, but the basic nature is that it is an armed conflict which is causing significant loss of life and property to the people of India and to the people and to the property of these people. So I wanted to understand, why aren't we signifying this term as international war? Because if the terrorists are attacking in my country, where these terrorists are coming from, they are not coming from sky. There has to be some source which funds them, trains them, and all that. If all this is known to the state, then why state is not taking appropriate action, which it is duty bound, in order to protect the Indian lives and lives and property? So that made me start my journey to understand the legal aspect of it, because, as you know, the war can be understood in two ways. Number one, war can, okay, it's not moving anywhere, I'll continue that. Okay, so war can be understood in two ways, either by objectively looking or by legal consequence of it. By objectively looking, we have various definitions of various scholars, where you see the exchange of armed violence between two groups. You identify two groups and you see that there's exchange of armed violence. That means it may be weapons or any kind of things. That situation qualifies as armed conflict. This is objectively you can identify. That means if you are third party and you're saying that two parties are exchanging arms and ammunition and weapons between themselves or among themselves, this is basically a potential situation for what we call an armed conflict. But the larger question comes: how do we understand it in terms of law? For example, the concept of peace and armed conflict are completely opposite to each other. If a state is in armed conflict, the state cannot have a peace. And if a state has a peace, then it cannot have an armed conflict situation. But in my state, both the situations are existing simultaneously. if if I want to analyze a state's its status, whether it is in law or whether it is in the state of armed conflict or not, we can simply go through the constitutional or other statutory measures that it has taken in order to counter such situation in its territory. For example, if you remember, Professor Eli in his first explanation alluded to the 2016 counterterrorism statute, where he said that now we have moved from emergency situation to a normal situation. That means the terrorist activities will not be considered as necessity to invoke emergency powers. It is enough for a statute to play its job and to empower those who are supposed to take counter-terrorism activities within that legal framework, if I understood it correctly. So similar situation is happening in India. Because there are studies, even if I go more objective studies, I found that Upasla University's Peace and Conflict Institute has established that if battle-related deaths are more than 25, then you can say that the state is definitely under an armed conflict situation. And in my country, it certainly exceeds, far exceeds the number, the 25.
Sorry, who said it's 25?
Upasla.
Uppsala.
Okay, Upasla.
Okay, because we use a threshold of either 1,000 or 10,000 in political science, and that's the 25 is not pretty low.
Yeah, I will forward you the link. They say 25.
Okay.
So the point was that in my country, it's of course far more than 25. I mean, be it citizens, be it armed forces or other things. Therefore, that brings me to the analysis part of it, that how the international law has defined protracted armed conflict, how my country has responded to this definition, and how the internal courts have defined the concept of armed conflict within India. For example, the whole distinction between international law and municipal law, of course, if you belong to Kelsenian school of thoughts, who believes that it is monoism, that means international law is indirect to govern the individual behavior, then it's not the thought process for you. But if you belong to the tourist school of thought, which believes that international legal system is altogether independent system from the municipal legal system, constitutional legal system, then this is where I come from. So my concept was that this is the thing, that if you see that protected armed conflict takes its birth, and any matter of armed conflict is inherently an international law matter. Municipal law cannot declare a concept of war itself. For example, in India versus Pakistan case, there was an interesting case which is cited by Jerome Dalton in his book War, Aggression and Self-Defense, in form of an arbitration case between India and Pakistan, where the Pakistani head of state went on the public forum, that is, he used the radio and said that we are at war with India and this and that. But the arbitral tribunal rejected his claim, saying that just by declaring head of state that it is war, it's not sufficient to have the war. That means the international law becomes the ultimate authority to declare whether there is a war or not, and it is inherently a subject matter of international law per se. Therefore, if we are searching for the definition of protected armed conflict, it will be great injustice if we do not go through the legal regime of international law and such. Protected armed conflict is nothing but a species of a general kind of a genus of armed conflict. So, an international armed conflict is basically international armed conflict or non-international armed conflict. This is the criteria based on the participants in the Belligerency. Now, none of as you all know, that it is Hague Convention, and then the Hague Conventions were codified into Additional Protocol 1, and then the other conduct of warfare modalities were incorporated or codified into the 4 Geneva Conventions. None of them define what is international armed conflict. For example, Common Article 2 Geneva Convention talks about its applicability in the situation of war, armed conflict, occupation and all that, but it is completely silent on what does it mean to be an international armed conflict, or what is mean to be that a state is in that situation where the invocation of IHL rules codified under these instruments can be invoked. Therefore, then I went ahead and found out that, okay, there is no definition of international armed conflict, but there is a definition of deductive method of definition of protracted armed conflict under Additional Protocol 2. Under Additional Protocol 2, Article 1, it defines non-international armed conflict in 2 clauses. Clause number 1 says that anything which is not in the Additional Protocol 1 is basically a non-international armed conflict. And clause 2 gives a little bit more expansive definition where it says that, okay, if there is a dissident force and it has a control over a certain part of territory and ability to have a structural form of resistance, then it is, and if it's involved into a conflict with the state, then it is a protracted armed conflict. So these criteria were given for the protected armed conflict, but there was further confusion created by Additional Protocol 2 when it says that, okay, even if within that territory, if there is an armed conflict going on, however it is connected with racial oppression or right to self-determination movement, that is ipso facto non-international armed conflict. So that means if a state, within a state, well within the territory, if 2 forces are fighting with each other, but if they somehow can relate their conduct of warfare to the cause of self-determination or other grounds that mentioned therein, it will be an international armed conflict. That is as confusing as it can be because no one knows what exactly it means to be right to self-determination. At least under Article 55, we read Article 73 to 76 of the UN Charter with the purpose clause of Article 1 of UN Charter where it says that people have right to self-determination. Many people even were doubting whether it has any positive normative value under international law or not. It's a mere declaratory principle or it has certain normative value. That's not my part. I'm not going to go there. So coming to this thing. So you saw that the final definition, some authoritative definition came from the appeal decision, the interlocutory appeal decision in the Tabitha versus prosecutor case, where the court took it upon itself to define what it counts, what it basically means when you say protected armed conflict, because you all understand that Yugoslavia was a very unique case. What happened there was a federation of various plural national societies, and then when they started fighting with each other, there was a dismemberment, and dismemberment created very interesting scenario. For example, in Bosnia, there was some Serbians who were present, those who didn't want to be Bosnians, they have their loyalty with the Serbians, and they were fighting with the Bosnian government. So the international tribunal had to determine the nature of conflict, whether it will amount to be protracted, whether it will amount to be non-international armed conflict, international armed conflict, all this because the statute of the ICTY mandated that you can only try those offenses which are related to or in connection with, even for crimes against humanity, in connection with the armed conflict. So this connection argument was essential for them to determine that whether the existence of an armed conflict was there or not. So so this is the definition that they gave, that an armed conflict exists whenever there is a resort to armed force between states, and you can see that this definition has inherently 2 limbs. One where it defines international armed conflict, and in the second limb it defines non-international armed conflict. And non-international armed conflict can further be subcategorized between, if it is between governmental authorities and organized group, and or between groups within a state. So there are 2 different groups having a different claims within the state that can also be constituted in protracted armed conflict for the purpose of international criminal tribunal. Next. Yeah, so I have done this part that you see that none of these positive international law carries an authoritative definition. One word should also be said about their applicability, because not everyone is party to these protocols. Their customary status is in doubt, because you know that a customary status is basically the declaration of a judicial body, and the only authoritative study was conducted by ICRC regarding the customary customary nature of these rules. And they also kept silent about the definitional aspect of these conflicts. So there's nothing authoritative can be. Okay, it's working now. Okay. So this is the thing when they have defined international armed conflict in positive international law. They also provided for certain exceptions, and this is where the federal conundrum starts that I'll talk about. They said that situations of internal disturbances, tensions such as riots, isolated and sporadic events of violence would not amount to, and that's rightly so. But this, if we see terrorism, there is a book being written on terrorism, and there are two schools of thoughts. One says that terrorism should be studied as sui generis, of its own kind. It's something different from normal protracted armed conflict or normal crime of murder or anything because of its inherent nature. The school of thought says that terrorism is nothing but it's simply a kind of a criminal act. You can associate it in any kind of situation, be it in armed conflict or be it in peacetime as a crimes against humanity, but essentially it remains a criminal activity. But that's not my subject matter. I also pointed out that this is the disturbing clause that in exception we find that if something is international non-international armed conflict, but if within a territory two conflict forces between the government and other forces are fighting with each other, and the other force successfully claims that we are fighting for right to self-determination, the international community and the local authorities are bound to deal it as international armed conflict. Now, exception 2 is prime example. Okay, I did not mention exception 2. You see that there is also General Assembly resolution on friendly relations, in which it is incumbent upon various, and you all know General Assembly resolutions are not binding, but in various cases this resolution has been turned as customary international law, such as Nicaragua case. In general, if you read these resolutions, they have also mentioned that if your territory is being used for certain purposes, it could be considered as non-armed conflict. If from your territory you are promoting something which is disturbing the peace and other kind of situation in other territory, this will be an obligation on you under international law. Now, exception 2 is prime example of structural shortcoming of international law. The problem with the international law is that, as you saw in the previous presentation, that there is no coherent structure. It has created the problem of what International Law Commission has provided in the form of fragmentation. I suggested further it is not only fragmentation, it is also the repugnancy between two laws. So not all the conflicts between two international norms is necessarily a conflict between them. There can also be situation of repugnancy. For example, in even a constitutional society, we see fragmentation. For example, there are various tribunals, specialized tribunal, unlike the previous old days when you had one good court and that court used to have all kind of jurisdictional power. Now you have tribunals for various special statutes, and these tribunals take care of the subject matter that they are supposed to adjudicate upon. So fragmentation is there even in the municipal system, but in the municipal system you have one authority where you have to check whether all these fragmented principle is constitutional or not. But there is nothing in international law where you can say that whether all these fragmented principles are international or not. There is no convergence point. So they can be very much contradictory and conflicting to each other, yet they kept their identity, independent identity intact within the structural edifice of international law. Now, I just simply found out that the study of terrorism basically was started by United Nations through this resolution in the backdrop of Munich attack on Israeli soldiers. And that's how they started taking terrorism as a sincere study. But again, their finding was so, I would say, I don't know what their finding was that the causes of terrorism are basically alien rule, self-determination problems, and all that, and so forth and so forth. So that means if the Israeli people were killed as in their sports villa, the reason was the issue of self-determination, and that's what led to the killing of these persons. Rather than going into the exact content or exact nature of these conflicts, whether it should have its outreach beyond a state. That means if you have a self-determination issue in the territory of Israel, can you go beyond Israel to kill everyone who is Jew and all over the world? For example, in India, the Kashmir is one of the boiling point between India and Pakistan, and then our neighbor very nicely supports these kind of non-state actors. They came and killed people in Mumbai. in the name of Kashmir conflict. So the point was that, let's say if Mumbai was another country, if you have a justified, let's say even justified cause, can you take it out and cause these kind of mayhems all across the world, and would it be justified? So for example, if you are a right to self-determination, if your cause of right to self-determination is justified, the armed conflict turns into an international armed conflict, then you become a prisoner of war. If you are captured by the enemy, then you are not supposed to be prosecuted for these crimes, because these are legitimate actions. These are legitimate, what we call under Article 42 or 52 of the Additional Protocol 1, legitimate targets, right? So these arguments become so weak, because even if we go by the strict definition of military target, the collateral damages are never denied. Collateral damages are something which all the armed groups have, or armed forces have argued that it will take place. We cannot ascertain that if we want to kill Mr. X and no Mr. Y and Z would be ever killed. So even if a person fighting for a cause of right to self-determination kills someone else who he didn't turn out to be, that still would not be a crime per se, because you can say that that's a collateral damage. Necessity. So the thing is, how far can you go to justify these arguments of self-determination? Would it remain within the territory, or you can take out the nature of belligerency beyond the territory of all these people whom you're supposed to be causing problem in your cause? That's the problem. So I had a problem with their finding, but anyways. Now you see the problem in international law again starts surfacing. They are saying that anything which is self-determination cause would be an international armed conflict. But now the Security Council resolutions have started saying that no cause justifies violence. Now, if I have a right to be a legitimate warring faction to claim the benefits of IHL, then you can't pass a resolution saying that no cause justifies the violence for any objective political goals. And this is where you again see the fragmentation or the conflict between two norms of international law. And I have quoted that, for example, the most recent one is 2253 resolution adopted by Security Council, which is of course in continuity with the first one, 1267. Here it says that reaffirming that terrorism in all forms and manifestation constitutes one of the most serious threats to peace and security, and that any acts of terrorism are criminal and unjustifiable regardless of their motivations. But this is in direct conflict with what the positive international law says. Now, the question would be, which norm will trump the other one? This is a Security Council resolution, whereas that is a customary international law or a positive international law right given to you by the international law. So again, the question of repugnancy of law or international law, fragmentation of law, or conflict of two norms that you may see is occurring here. One may say that the treaty norm and the resolution, because the Security Council resolution is not a treaty, it's a resolution. The treaty norm, can a treaty norm in conflict with the regulation norm would be same as the same, will be at par as two equal norms, or one will be here or other, because one comes directly from the treaty, another comes from the Security Council resolution. You all know that Article 103 of the UN Charter says that if there is a conflict of two obligations between UN Charter and other treaty, then the common obligation under UN Charter prevails. But then again, the point will be that if the Security Council resolution is under Chapter 7, it's not binding, then what will be the nature of this and so forth. Okay, I guess. So we have seen that there are two objectives willing to determine any protected armed conflict or any armed conflict, legal and objective. Objective we discussed. Now we will see these two are the objective way. That means you go and see that people are fighting, throwing stones, throwing missiles, exchanging bombs, and killing each other. Or there may be simply number of deaths counted, and then you can say that. Next. So now, legal test. How do we determine that within the municipal corporation, within the municipal society, constitutional society, whether there is a protracted armed conflict or not? International armed conflict, straightforward, no problem. But if there is, I know international armed conflict is also not problem. It's not that easy because of the agency test and all other things, and then there's so much complexity involved. But We'll see. We'll take that state versus state war is an easy case to assess, so we'll keep that aside. But if within a state, whether there is an international protracted armed conflict of any kind is existing or not, first test would be the international law test. That means if I'm a lawyer, I would go and analyze if there's a UN resolution pertaining to those situations. For example, if there's an Israel-Palestinian conflict, I want to assess that whether there is anything legally I can determine if this conflict is protracted or international or internal. Then the first would be to go and find out in international law if there's any resolution. That would be the first step. So same for the India. In order to find out if there is a protected armed conflict in India, one can go and examine Security Council resolution. With the exception that I have pointed out that Article 2, Clause 7 UN Charter establishes the principle of non-intervention. We simply say that if the state, if something is a domestic jurisdiction of a state, then the Security Council or United Nations is prohibited to intervene in those matters. The only exception is that if the Security Council acts under Chapter 7. However, there is a question: what is domestic jurisdiction? Who determines domestic jurisdiction? Is it the state who says that domestic jurisdiction, or it is the international bodies who determine what is the domestic jurisdiction? An interesting case arose between India and South Africa way back in 1948 or 1948, when both the countries newly became independent. The Indian government has a problem the way the South African society were treating Indians under their apartheid laws. They went to Security Council and said that they went to United Nations and said that please do something in order to force South African government to treat Indians, persons of Indian origins in South Africa with a better laws. The question was that can you intervene if I have a law which discriminates? Can United Nations go and intervene in that matter, because that is essentially a domestic jurisdiction? Interestingly, in this case, the United Nations did intervene, and it found that the laws of apartheid applied by the South African government was indeed violation of the Universal Declaration of Human Rights and another kind of non-discriminatory regime that the United Nations propagates. So, coming back to the Indian, after this clause, we find that for India there is not much Security Council resolution, except for that there is a Security Council resolution regarding the Kashmir dispute vis-a-vis India and Pakistan. However, all those resolutions were passed under Chapter 6, and therefore their binding value is also in question. However, the other thing is that they have not spoken anything about the disturbances within the India propelled by proxies by our neighbor in our territory. So the question is that they did pass a resolution regarding the nature of conflict between India and Pakistan, but they did not pass a resolution what was brewing within the territory of the Indian Jammu and Kashmir. Therefore, again, the determination in international law was not final or definitive to ascertain whether in India there was a protected armed conflict or not. Now, apart from the international law test, I move to the constitutional test, the municipal law test, that whether we can identify and ascertain if there's a protected armed conflict situation or not. Please tell me when I'm about to finish. So, if I analyze any constitution, and as you know, most of the states have written constitution except Israel, UK, and New Zealand, I believe. All the states have written constitution, and they do provide for emergency situations. In India also the same is the case. Article 352 of the Constitution of India provides for the emergency powers. But these emergency powers can only be exercised if the government of India or the Union Parliament establishes that either there is war or external aggression or armed rebellion. If these three grounds are there, any of them, emergency can be proclaimed, and it can be proclaimed not for the whole territory of India, it can be proclaimed for any specific part of the Indian territory. Now, what are the consequences of the proclamation of the emergency in Indian society? Once the emergency is proclaimed in India, the direct consequence of the proclamation is that the freedoms that are mentioned under Article 19, such as freedom to form an association, speech and expression, freedom to move anywhere freely, all these are taken ipso facto. That means here there is a proclamation of emergency, and your right to move court for enforcing these rights against the state ipso facto gets suspended for the period of proclamation of emergency. Another consequence of the proclamation of emergency is that the Union takes over the executive as well as the legislative power of the state to the extent it deems fit for the security and integrity of India. The another consequence of the proclamation of emergency is that the state gains those power which it otherwise would not because of the restrictions imposed by the fundamental rights, which say that the state shall not make any away or amended or abridges the fundamental rights. These limitations are straight away lifted, and the state can make any laws, and now these laws cannot be challenged on the basis of that they are basically violating the reasonable criteria mentioned in the Constitution because of the proclamation of emergency. The only criteria is that all such laws which takes away these fundamental rights, they must say that they are doing it as the result or the consequence of the proclamation of emergency in India. Now you can see that we have 4 times proclaimed emergency under Article 352, one because of the Chinese aggression, and 3 other times because of the Pakistan. We had a fight with Pakistan in 1965 and in 1971. We proclaimed Article 352. After that, there was no proclamation of emergency in India, even though we fought the international war in the form of Kargil armed conflict, where certain Pakistani troops disguised as the local Kashmiri Mujahideens captured the mountainous terrain of the Kargil and pretended to be from the local population. Indians realized that this was not the case, but still they kept the war within the territory of India and they did not take it away. Neither the government of India proclaimed the emergency. Now, another constitutional duty that flows is Article 355. Article 355, as you know, in any federal structure, the concept of federalism is that 3 powers are the exclusive domain of the federal structure: defense, communication, and there's one more I'm forgetting. So defense is one of them, where the states are supposed to be protected by the union or the federal body. Now this is where the federal conundrum starts. If there is a state in India, and India is quite 7th largest country in the world, it's a huge territory. Now, if there is a little problem or some problem in this state, and the government wants to tackle them, the first problem will be that under the legislative schemes that the Constitution has, the crime or public order is in the inherent domain of the state. So if the armed forces are being sent to that territory, the state will say, no, you cannot do that because that is for us to deal with, because that's a law and order problem. Because there's always political coins to gain from it, right? If you are a political party, you know that you have a certain kind of vote which will be upset if these movements are crushed by the union. So there is always resistance by the local states not to intervene when the state is supposed to, or the state wants to protect them. Therefore, in order to avoid such situations, Article 355 has been incorporated in the India, which casts a duty upon the state to protect it only on 2 grounds. That means the state can interfere in the armed conflict situation or in a turbulent armed situation in a state if the state is convinced that either it is external aggression or it is internal disturbance. Now the question is, how do we know what is external aggression? At what point of time a situation becomes external aggression, or at what point of time the local riot or local problem or tension within a community would be considered as internal disturbance? Because always remember, police force is different from armed force, and armed forces are at the disposal of the union. So when union says that it is an internal disturbances, then the armed forces will be dispatched to this territory, and now the armed forces will be performing those powers which otherwise is exclusive to the police force. For example, armed forces, they only get right to kill or to any kind of right to fire when there is a war. If there is no war, if a soldier opens a fire on its own citizen, he is as criminal as anyone else. No law can protect him from killing any person. So his license to kill is only applicable, as people call lex specialis in IHL, if IHL-like situation is not there. He is simply an armed person with as much restriction as any armed person has. So now another problem is that if the armed forces replaces the police forces, what kind of power do they have? Can they arrest a person? Can they investigate a matter? Can they prosecute the matter? Can they seize and check and do all these kind of powers, which is exclusive for the police? And if they can do it, can they do it with the police forces? And if they are functioning under the state, in the territory of a state, does the state get the power to regulate the armed forces, which are basically under the union structure, in the federal structure? So these kind of problems that we face. For example, I have framed one question at how armed forces of the union can be deployed in the state. What are the legal criteria for that? Next. So just a little bit talk on the concept of Indian federalism. There are two kind of the various theories. This is for the political scientists to come up with the various theory of federation. But the two concepts of federation that exist in international polity is centralized federal structure and decentralized federal structure. The centralized federal structure is basically those federal which are organic federalism, which are not the result of a conquest or the result of a domination of one political force over the others. So in India, you'll find this centralized structure. That means union is more powerful than the state. Whereas in all other, in most of other federal structure, you will find that the states are more powerful than the union. What does it mean to be powerful? Basically, if you see the American Constitution, they have a list of what laws can be made by the federal government, what laws can be made by the state government, and then there is something called residuary power. All the residuary powers in America rest with the state. Similar is the case with the German Constitution. When I was reading the German Constitution, I found that under Article 72, 71, 72, 74, they have defined the list for the union government, for the landers, and then they have what they call residuary power, which is exclusive domain of the landers. That means whatever laws are not described in those lists, the states of Germany have the exclusive power to make law. In India, it's the other way around. It is the union that gets the residuary power. That means if there is any matter which is not exclusively laid out in those lists, the union will step in and can make the laws. And the only test that the courts can lay down that the pith and substance of this statute does not override those which are within the exclusive domain of the state. That's it. So this is where we see how centralized the Indian federal structure is. This was the case when I was researching. I found very nicely summarized what is the characteristics of Indian federalism, which is not relevant here. Now, so I have explained the federal conundrum. I told you that how the union, the armed forces, it's one thing to imagine them in armed forces, but their all powers are meaningless if they are not at war. The effectivity of army is that they have a respect from people. If the army loses the respect of the people, its effectivity will be gone. It will become useless because the power that it derives not from the barrel of the gun or the various equipment it carries. The power is that the people's faith in it. So if in the federal structure you are operating in a place, the first question would be how do you have that power? Because that power is given by the statutes to the police, and you are not a police and there is no war. You might carry a weapon, but you do not have right to open the fire. So first legal question arises, if you're asking a person to be stopped and you're frisking him or checking him, the question would be how do you get these powers? So the first federal conundrum is here, that how do we synchronize the armed forces power versus police power, and if there is any dependency between them, and how Indian response has come to that. And of course, there's what I found that this conundrum is internal and external both. External is that if the state Union of India is shying away from declaring a war or a situation like war as a war, it is also not doing justice to the international law. For example, in Kargil conflict, it was a war, everybody knew, but the government of India never declared it as war. We fought for 18 days, we suffered heavy casualties, both the sides suffered heavy casualties, but it became for all legal intent and purposes a non-international armed conflict. It was something that India did within its territory and never invoked neither emergency nor gave any chance of application of international humanitarian law. So the first conundrum is here that if they want to declare declare the war, then you might have international politics coming into play, and we have burnt our hands in Kashmir, where at the time when the invading forces were coming into Kashmir, the Prime Minister Nehru came to Security Council saying that we have been invaded because the instrument of accession has been signed. He thought that the international community in general in Security Council will say that okay, these forces are basically invading forces and they must go back. Instead, the Security Council passed a resolution which said that stalemate, everyone should be staying there. These forces would have to later on removed and all that. I'm not going to go there. So the point is that even if you want to declare, you are so afraid of the international consequences, the international politics will play out, that you do not do justice with the international law itself. And then the whole bunch of IHL, its application, and all this is blown in the air.
How are you from there?
5 minutes?
You won't get much of a discussion.
Okay, then I'll be very fast. So I don't know how much. So I'll just take 5 more minutes and then I'll finish. I'm sorry, I didn't see the time. So the point is that the Indian courts have point out how to distinguish between internal disturbances, how to distinguish between external. The professor has read my paper. I have quoted them. I'm not going to discuss with you now because the professor understands it. So the point is that they have found out this solution. When do you call a situation internal disturbance? When do you call a situation armed rebellion? When do you call a situation external aggression? And all those scenarios. And they have the constitutionality of these armed forces was also called into question, and the Supreme Court of India has decided that these kind of statutes which give special forces, because I told you without these powers, these armed forces are as good as nothing. They are armed bands within their own territory, because there is nothing in the Indian Army Act or other Armed Forces Act that gives them special power to go and perform these kind of acts, which is otherwise a police action. So these acts which empowered them, the power of police functions have been upheld by the Constitution of India. But still, the problem is that where these forces are basically stationed right now, a huge amount of disaffection vis-a-vis the armed forces has grown up, where you will find that these armed forces are not appreciated by the people, because when they come to the rest of India, they say they have a lot of civil and political rights, whereas we are subjected to so much frisking, so much restraints on our civil and political rights, which has led to what I would say is the conundrum is a fallout, because if they invoke it for whole of India, an emergency situation, then entire India is paying for a region which is resting in a part of India where the rest of them are not, and therefore the states have not, the union government has not used their power of invoking emergency because of all these regions. And from this I shall stop. Thank you.
So thank you very much. Should I move anywhere so that I'm being
Stay where you are. Stay put.
Can we sit here also, if possible?
No.
No. I mean, 1 second also, the slides.
Full screen one.
One second. Okay. So, yeah. So, thank you. So it was a fascinating explanation of how India's political conflict of laws seem to be portrayed. On the one hand, we have public international law, which I will focus on, as I'm not an Indian constitutional law scholar, as you can imagine. And then on the other hand, of course, we have national public law, namely, and more particularly constitutional law, the other public laws at large. And so this set of conflicts of law is what the paper discusses. My contribution can obviously be, realistically speaking, focused on public international law, and I want to suggest one simple observation that I think runs along the lines of everything I'm about to say, and this is the choice I think you want to make, a methodological choice, mind you, but the choice you want to make, and it has to be a clear choice. You either go for an interdisciplinary paper, you can have a lot of policy thrown in, you can have many of the ideas you have suggested play out, or you make a different decision. A decision you could make, or you could avoid making, but then you should choose, is have a paper that has much more positive law in place, and if that is the case, within customary international law, you have a long list of binding customary international law principles, to whom I refer briefly in the minutes I have, with the purpose of helping you frame the choice of going to the direction of a more positive international law paper, okay? Which you do in part, of course. So that is not to say that the decision should be clear cut. It should be more focused on one aspect than as opposed to on the other. I wouldn't go for the choice of having both methodologies, so to speak, in place. Choose one of them, have a modest paper out, or can have then a second modest paper out, having a second methodology in place. If you feel like it's nothing original, so to speak, so we've seen that many times. So what I'm about to do now is go through the maze of this conflict of laws, as I suggested. On the one hand, we have public international law with emphasis on IHL, and on the other, constitutional Indian law, which obviously I'm not familiar with. And in so doing, what I would want to try and do, giving one more disclaimer, and that is that when we move from a Mac computer to I dare say, non-Mac computer, some of the letters became confused, not to say gibberish, and so I apologize. I still know what I want to say, so I'll manage without reading the slides, but you might have a bit more of a challenge, given that moving from my Mac to Michal's computer has added some price. You will be paying, I'm sorry for that.
I'm sorry for that.
It's fine. I'll just add another thing, which is that for your purposes, I'll give you you'll have the slides from Michal, which already got it, and so you feel very invited to use them as we go along, okay? So if to prescribe to what are, to the best of my understanding, the four main arguments that the paper, or propositions that the paper assumes within the context of public international law with emphasis on IHL, these four propositions are the following. Within this question of conflicts of law, given the case in point of Kashmir, of course, mostly of Kashmir, not only, but mostly of Kashmir. And so these are the four propositions, if I may. The first one is that India is neither, and I'm quoting, neither in peace or in a declared armed conflict, which makes part of what is argued to be a conundrum, a complication that makes life more complicated for whoever wants to have conflict of laws resolved, right? So that's one complication, so to speak, that the paper assumes and presents. I want to argue and rebut to some degree this proposition and show you that maybe things could be seen simpler than proposed in the paper, and I'll try to do my best to explain that point. There's a second proposition within this conflict of laws that the paper makes, and I'll again try to rebut, or at least challenge, and that is that IHL applies more as a question of fact than a combined question of law and fact. That is, again, a proposition I want to challenge and see if we can say a few intelligible things that will help us to see if the conflict of laws is possibly less confusing, less of a conundrum than we are said it is. And third, armed conflicts do not have a distinct identity under international law, And in other simpler terms, the argument, or so to say, the proposition the paper assumes is that we don't really have a good definition of armed conflict within IHL. And so that is another reason to why we have a conflict of laws. The conflict of laws being so complex or conundrum. So again, that is something that I will try to rebut briefly. I'll give you a few hindsights of how to go about it, and quite simply get rid of that proposition quite frankly. Okay, but that would be the third point I'll refer to as time goes by. And I'm not sure I'll get to everything, but then you have the slides and have a conversation later on, a few of them if you need, and then you'll be fine. And the fourth point, proposition that the article makes. If you want to follow me more smoothly, change it to 1 page per slide, and then it jumps like a PowerPoint presentation, right? The critical question, so to speak, of which type of an armed conflict is again a source of confusion, so to speak, and that's why India, as the author explains, is having a difficult time in finding the right balance between this conflict of laws and constitutional law, with constitutional Indian law on the one hand and public international law and IHL in particular on the other. Again, that is a simpler, rather simpler argument to rebut. I would leave you with the following argument, sub lineup, which is, let's see if we can focus on the two main arguments, which are the first two main arguments, and see if I can help you not rebut them, but actually clean cut them and clear them. And by saying that, I want to add that for the third and fourth proposition, I think you should get rid of them. And I'll say a few things about how you possibly can get rid of the fourth one as well. I mean, again, just to remind us all to be all on the same level.
Yeah.
Level the playing field. The main point of what I'm trying to do is, again, to clarify the two first points and to rebut and not nullify, so to speak, the two remaining points, which I think are wrong, simply. Okay? Let's do that. Let's start with the first point. The first argument, proposition, what have you, that the paper makes is that India is neither in peace or in a declared armed conflict. And in reply, I want to make 4 propositions or give 4 replies concerning the principle of customary declaration of war. Nothing too original or some things that you possibly have an idea about or possibly know in detail, but then just to be on the safe side, the paper does not, of course, relate to these points, and so I have to put them on paper. And you can't not mention this principle of customary declaration of war, which is, the nooks and crannies of how to go about the lack of declaration of war by India through other generations since 1947 till this day, right? India has not declared, by the way, same as the United States since December 11th, the day that we remember in infamy, hence Pearl Harbor attack, and the declaration by Roosevelt, declaration of war, the last declaration of war ever by the United States. And in addition, I just mentioned Israel, which has never declared a war, ever, okay? We had 6 wars. You can argue what a war is, but then some of them are classic total wars, some of them possibly armed conflicts, short of war, possibly wars undeclared. Be that as it may, we have not declared wars, and so we also are familiar with this question. We have some national laws relating to it, criminal law and other laws. I'm not going to go into it, but then on a more abstract level, given the international legal level of this compulsory declaratory of war principle, I want to say the 4 arguments. So it is true that in the past, that is until 1945, with the addition of Article 2, the general or the common Article 2 to the 4th Geneva Convention that has nullified the need to declare war. Until then, and not after that, but then only until then, it is true that a clear warning or an ultimatum would be enough to put a declaration of war in place. And so it is true that along the lines of these 2 settings, India has never declared a war, and hence maybe a war never went into place. The point is, India was established 2 years later, so that point, that 2 settings do not relate to it. It's nice in principle, it's nothing to do with India in reality. What is interesting and relevant, of course, is what happens 2 years before India is established, and then that is the implementation or the inauguration of the 4 Geneva Conventions, the principle that led to the 4 Geneva Conventions, Section 2 in 1949, of course, and that is the idea that you do not need to declare a war to have a status of war, and more than that, you do not need to declare a war to have the laws of armed conflicts in place under the assumption that you have enough of what they are referred later on, referring to Tadic, Limage, and Harabinage. The 3 cases starting with Tadic, of course, with the 2 conditions and both broad conditions for the application of the laws of armed conflicts, namely intensity and organization, level of organization, which we'll refer to it in a second. But that said, 1945, but then in particular 1949, with the adoption of Section 2 to the 4 Geneva Conventions, it became sufficient to start belligerency without needing to declare a war. So India doesn't really have an issue, your paper doesn't really have an issue, I think, I'm actually confident, vis-a-vis the point whereby India has not declared, it doesn't need to declare. I think that is a clean-cut argument that you can simplify and see that you don't confuse the reader and maybe get it wrong, okay? Because that is quite solid ground here. If you want to play with some rationales, so the 2 rationales to why IHL application doesn't need any longer, is not anymore justified or based on the justification of the principle of declaratory war, the declaration of war, of course, are one, the introduction of nuclear weapons and nuclear belligerency, or the potential of nuclear belligerency. India, Pakistan, of course, come to mind. Martin van Creveld, given that we don't want to totally ignore interdisciplinary studies. So here you have Martin van Creveld, who is a military strategist and historian, military strategist, to expand and details to which degree the threat of nuclear wars has changed the narrative whereby countries see themselves in a status of war, even without belligerency in place. But then that's a new breed of a status of war, or at least a potential status of war, given that once you have nuclear armament in place, it's a different beast, so to speak, and then that could be an argument that strengthen the points that India, even also for that purpose, given that consideration, even more so does not need to declare war, which is something it doesn't need to do, given
I have it in mind.
positive international. But the positive international legal aspect, the nooks and crannies are not in the paper. See that you throw them in, and then you have it nice, right? Secondly, a second rationale is the one that obviously relates to United Nations Security Council and the 2 major changes that occurred with the establishment of the UNCS, right? And that is, one, to enter belligerency, you have to have a Security Council resolution, right? This is, I am assuming, well known to you all. And the second is the trend whereby the United Nations Security Council is doing the best it can, giving the realpolitik at the UN level, to push individual self-defense to anything but individual self-defense into collective self-defense, again weakening sovereignty, the rational sovereignty for these 2 main propositions, on the expense of India's ability to argue for a conundrum in this conflict of laws, whereas there is no real conundrum if you don't need to declare, and you don't have the discretion to decide if you want to start war or the belligerency, given that the international law is taking you to a collective self-defense and to the need for Security Council resolution, the nuclear aspects, which I mentioned earlier on, as the main rationales to why sovereignty at large has weakened, and that is the point. But the second argument is the one that I'm not going to nullify it, I'm going to solidify. And by so doing, I'm not being diplomatic. I actually want to solidify your argument. I want to make 6 propositions. I hope we have time. It's already 4 and 3 minutes. I'll do my best to not to speak too fast, but then see if we can cover some material. And again, you have the slides, and contact me by Skype or whatever. You have my slides. I'll be delighted to help. Anything you would ask. So let's do it while maintaining the principle of Freudian principle of joy, so that we're enjoying ourselves in the process. Okay, the 6 propositions, or if you want, critiques, that would leave your argument in place but then solidified, are the following. I want to add another thing, a subtitle. Everything that I'm about to say, these 6 propositions are based on a binding customer international law, and so it is all binding international law. It's not nothing that is less than binding. So you have no choice to kind of refer to Luther. We have Germans here, so Luther says that here I stand and it cannot be anywhere else. So you cannot be anywhere else. You have to relate to these propositions if you want to talk about public international law. So these are the 6 propositions, 6 critiques, as I have referred to them. A, it's irrelevant if India is opinion juris-wise silent. It's almost irrelevant. India doesn't need to, in the specific situation we're discussing, as opposed to discuss other situations, but the specificities of the Kashmirian conflict, and I'm summarizing it, it is much less of an issue and possibly irrelevant if India has been clear about its opinion juris, right? Mens rea, so to speak, right? Analogy to criminal law, vis-a-vis its position over the relevancy of IHL on the conflict or to the conflict. And the idea is quite simple. If the rule says that given sufficient state practice, which India of course has, mobilizing tens of thousands, possibly hundreds of thousands, and possibly here and there millions of Indian soldiers, and killing much more than 25 people, and I hereby wish to really kind of almost in dismay ask you, how can you mention 25 casualties as a standard? It is it's not the standard that I am, to the best of my knowledge, aware of, but nevertheless, it is way beyond what is in reality a situation. India and Pakistan, regrettably so, have led to a much higher standard of injuries.
I said that to determine if conflict exists, the objective criteria is if 25 deaths are happening, you can say that it is conflict. I'm not saying it is.
I'll refer to the Uppsala study later on again if we have time, which I doubt, but nevertheless, it's in the slides. So given that there is indeed in the Indian context sufficient state practice, it is not necessary to demonstrate separately the existence of opinion juris. That is the law. And yes, there is an exception which doesn't apply in the case of Kashmir, and that is that whereas whenever the opinion juris will be deemed to be ambivalent or ambiguous. And so with Kashmir, India's opinion juris is not ambiguous. India is quite clearly, and that is something you actually refer to, quite clear about not declaring, and then so there is no ambiguity, it's just a denial of the situation. So ambiguity per se is not taking place, right? Just a denying, but that is not the standard. The standard is of ambiguity. And given ambiguity, deciding if practice counts towards customer formation would need discretion along the lines of rationale, which I'll talk in a second. Just to put in brackets, the Lotus case, which is when we start with what is, as I said, binding customer international law, starting with Lotus. Okay? Because it didn't bind anyone in 1927, it is today binding customer international. The interpretive rule, whereas in India we don't need the interpretive rule because it's not ambivalent, but then if it is ambivalent, which again, it's not our case, but should you argue that it is ambivalent, then the two interpretive rules are the following. Applying IHL would be widely interpreted, or IHL would be widely casted upon a situation, belligerent situation, in the event there is need to protect peace and security, which clearly is the case in Kashmir, given that, as I said, we don't have ambiguity, so it's simpler. And then, if the issue at stake is the protection of human rights, again, classic Kashmirian nooks and crannies, I mean, there's a lot of it on the table. Nuremberg is where we start saying that. Nicaragua in '86, ICTY again is where that this set of ideas became binding customer international law. And then that is providing that there is no important, there is an exception, of course, and the exception is that it's binding that there is no important contrary opinion use. And here you need to play with the idea that possibly India has, I'm complicating, not simplifying or complicating, possibly has a contrary opinion use. Now that needs to be seen in detail. I'm not an Indian constitutional scholar. You need to look in detail and see if India indeed is opposing vehemently with its opinion use. I think the answer is, to the best of my understanding, that it is not the case. That you will in a better situation to see if the exception applies or not, and then take it from there as we see. So the exception was developed in the nuclear weapons advisory opinion in 1996, and Texaco versus Libya was an arbitration case from 1977 that led to binding customer international law vis-a-vis the exception, okay? Regarding opinion juris, as I explained. There is a second reply to the proposition which IHL applies as a matter of fact and less as a matter of law and fact combined, which again I think is not so accurate. And I want to solidify it by saying it is indeed a matter of law and fact. And so it is partly true. We should see that it gets totally true. And the second reply goes as follows. India has, as many other countries, almost all countries, given its commitment and obligations deriving from the fourth Geneva Conventions, and in brackets, I'll just add, before I get to it later on, India has not signed the additional protocols. If you don't know that, nice to meet you. India does not see eye to eye the additional protocols, by the way, same as the United States and Israel. And many other countries, not many, but a few other countries, you can seem to imagine, okay, including Sudan, Iran, whatever.
You never define a third.
Of course. So we have read Star of David, right? And the Iranian Lion is also, the Iranians also ratified the third.
No, in the Geneva Conventions.
Right?
In the Geneva Conventions, the Red Lion and stuff.
No, but then the third protocol from 2005 has to do with the ability to mix the signs of both Red Cross or the Red Crescent with the Iranian Red Lion, right?
They don't want it.
Sorry?
They don't want it with the Red Crystal. Not with...
Yeah. And then, so my kind of ice-breaking proposition was that Iran actually played ball when it came to the third protocol, so they also know how to sign protocols, same as we do. So they're not worse than us on that level. So India's commitment to minimum considerations of humanity again binds India into adopting IHL, and in this conflict of laws being, in a situation where, again, referring to Luther, here it stands and it doesn't have any other way, right? It has to have the minimal, at least, standards of IHL in place. Common Article 3 of the Geneva Conventions refer to the minimal standards, elementary considerations of humanity, which apply to all armed conflicts, the two main conflicts, and then the mixed conflicts, which is my fourth point. And we're not going to get there, but there's a fourth point referring to the mixed conflicts, and then the two classic, international, non-international. All conflicts are bounded by Article 3, the common Article 3. You need to be clear that you have a minimum standard that applies, even if India wants to leave a conundrum, some challenging question in place, you still have a minimal threshold that India must guarantee. The paper doesn't relate to it. It's easy to throw in. That, just to be clear, comes from Nicaragua. Nicaragua explains that applies to all armed conflicts, and then that is where it starts being binding customer international legal principle with Nicaragua henceforth. Of course, ICTY and a second reply out of three replies to that commitment by India to the minimal consideration of humanity has to do with the great majority of propositions of 1949 Geneva Conventions that represent customary international law. And even in India, given that India has not ratified, not been signed, been ratified what is the important of two, which is the first additional protocol, still leaves India with the commitment to the minimal standards. Even if we can discuss the customary binding, standard of the first protocol, we don't need to discuss the common elementary considerations of humanity within the conventions themselves, whereas India is committed to it. So there's no issue there. Nuclear weapon starts the codification process into binding customary as well. And three, there's wide agreement that the ICC statute, which obviously relates quite closely to what is obviously the criminalized aspects of IHL, or became the joint criminalized aspects of IHL, they reflect, and that is important, existing customary international law. India is binded by the ICC. Here, India signed the ICC. India is binded. That's the way to catch. That's the way to catch India into, once again, IHL minimal standards. Once you sign the ICC reflects the minimal standards, in addition to the fact that you are directly binded by the common Article 3 to the 4th Geneva Conventions. The way you bind India through the Statute of Rome, ICC Statute of Rome, is explained and detailed, and what led eventually again to, as I said earlier on, binding customary international law, is the report of the Rebuttal Committee on the establishment of the International Criminal Court. That is how we started a process of codification of what became later on binding customary international law, that again grabs India and commits India, binds India into the common minimal standards of Article 3. Then there's a third reply to the proposition, your second proposition, right? And that is that India is in addition binded, nothing less than binded. It's binded by customary international law to respect and ensure for IHA. And we learned that from two sources. One set of sources are the Geneva Convention on the Protection of Wounded and Sick, which India is binded by from 1929, Article 25. The 1929 Geneva Convention on Relative Freedom of Prisoners of War, Article 82. India is again binded by these principles. The Geneva Convention Common Article 1, which is needless to say, so to speak. And I want to add additional Protocol 1, which India, as I said, did not sign. Nevertheless, this specific principle within the first protocol is customary as well. So India does not need to ratify and sign the first protocol, additional protocol, for that principle to apply, even if India doesn't see fit. It is still binding, assuming that as a classic Anglo-American system, customary international law applies automatically. You don't need to transfer it from transformation as you do it. And that is true for India as it is true for Israel and for many other countries within the Anglo-American system. So India doesn't need to agree or not agree. It is binding unless, and that is clear because it is still the same principle, which is unless India has a specific direct piece of legislation, primary legislation, I would assume is the term that you would recognize, but then Chakika Rashit in Hebrew, of course, that rebuts customary international law. But then I would ask you to argue that argument. I'm not sure you want to argue it if it's not clearly true, and I actually think that maybe you don't have an argument there, which is good, because that means we bind it by this. Okay. I want to be clear, we bind it also by the first protocol, additional protocol, on the issue of Article 1.1 of the first protocol that deals with the minimal standards. You understand? I'm still thinking about the minimal standards here, right? And in addition, the need to ensure respect for IHL is also, here there's a complication. I'm complicating my argument, not your argument. Here I'm weakening my critique, not strengthening my critique. I'm weakening my critique, which so far seems to be convincing, I hope. Now it's a bit less. Given that, you also want to look into military manuals. You want to look into military manuals to know what the opinions of the country, and to some degree also what could be related to its practice, right? If you do that with what is specifically the Manual of Indian Military Law of 1937, that is the Indian military manual, becomes complicated, given that India that does not abide by this principle, which is customary international law, and there comes an argument that India could be perceived, and that's an argument you must make, a persistent objector to this principle of ensuring and respecting for action. And that is an argument with persistent objector doctrine. You have 5 rationales, but conditions for the doctrine. You need to go through them, blah blah. Okay, but then, and there maybe we can possibly even cancel this 3rd out of 6 arguments in reply to your point regarding the fact that India should that you perceive IHL as a matter of fact as opposed to law and fact. Moving to the 4th reply, right? You're kind of bad on time, so I'm gonna see. I'm gonna finish the 6 points, giving the 2nd argument. I'm gonna leave you with the 2 remaining arguments, 1 sentence each, and then methodology if you want. If not, it's okay, but I'll give you the sentence, right? Okay, the 4th reply to your 2nd proposition, right? Fact as opposed to fact and law in combination, right? And that is that India may not encourage violations of IHL, through its many proxies, and in particular its armed forces, but not only. I'll make the list of who else is considered a proxy within the principal agent relations that the government of India has with its agents, so to speak. And that, again, is binding customary international law. You learn that from the common Article 1 to the Geneva Conventions to, again, additional Protocol 1, Article 1.1, India here didn't sign, we say that. But then here we do not have the Indian military manual to say that India does not abide by this principle. And you cannot, as I said, and you should be in a much better position to see if I'm correct or not. You cannot have, I don't see the purpose that the base ground to argue this, that on this specific argument, India is a persistent objector, but you would be in a better situation to see it. And then also Nicaragua, which adds another important observation, which makes India's commitment to respecting IHL and ensuring IHL via its proxies, its agents, much more solidified, is the fact that what starts with Nicaragua later on became binding customary international law, with Nicaragua saying, the ICTY, of course, with Nicaragua in 1986, saying that it is not only learned from the Geneva Conventions, the idea of course, ensuring and respecting for IHL, right? It is also known from the Geneva Convention, but in addition, hence the addition, it is also known from the, and I'm citing, from the general principles of humanitarian law, which are not the Geneva Conventions, to which the conventions merely give specific expression. So if you leave out the specificities of formal, positive, Geneva customary treaty law, Geneva treaty law, you end up having a more abstract level of orientation of public international law of IHL type, and then the general principles of humanitarian law outside of positive treaty law is an additional yardstick to kind of solidify the commitment by India to respect and ensure, okay, which is again binding customer international law. And if, again, I just want to remind, if, because India is an Anglo-American system, India does not have a specific law that rebuts part or all of what I'm saying here, India is committed because it is applied automatically, given that it's a customary public international law, which applies automatically as opposed to a treaty law, of course, that then does not apply automatically, and it's much more complicated to make a point against the Indian state, right? And fourth, again, a fourth indication to support the argument that India is bounded by the binding principle of respecting and insuring for IHL, also by law, not only by fact, and that, as I said early on, is less relevant. Nevertheless, it's the Hague Convention on the Protection of Cultural Property. If you would argue that India, within the context of Kashmir and other parts of Indian subcontinent, where India has, by the way, Bangladesh, of course, I didn't mention, and not only Bangladesh, it doesn't end with Kashmir and Bangladesh, and you know the story. If India has came to the, used the belligerency against cultural institutions, so once again you have another unique, colorful, so to speak, argument that deals with, right, cultural property. State responsibility, given state responsibility doctrine, and as we all know, we have a draft article on state responsibility from 2001, and Article 16, again, binds India and other countries that have applied the draft articles of state responsibility from 2001, as I said, including India, that the additional source that puts India in a position where it's a conundrum, so to speak, is smaller than we thought earlier on. And within the same second argument you make, then there's a fifth and lastly a sixth reply. I'll make the fifth and then the last sixth reply. I hope you're still following me and you don't start to miss your mother given the time of the day. That goes like this. India is bounded by its state responsibility doctrine, by the state responsibility doctrine. It is binding customary international law, given both international and non-international armed conflicts, even if India would be to argue that it's a non-international state, armed conflict still it is binding. I cannot see how India can seriously argue that it's a non-international armed conflict, and then given that India has not admitted IHL, this is a tragedy, I dare say, it's a point you want to consider, or making yourself, or at least analyzing yourself. And the sources are, I'm not going to go through all the sources. The implications are, of course, that the agents or the proxies are the organs and the persons in entities, persons in groups carrying orders, and private persons in groups, and the many type of agents you might think of that are applying India's military orders, right? The sources to that commitment, or to India's state responsibility doctrine commitment, or in other simpler terms, the commitment of India through the prism of the state responsibility doctrine to applying binding customary international IHL law, are the following four sources. The first, Geneva Convention, Article 51. The second, Geneva Convention, Article 52. It's for your paper's purposes, so I detailed it a little bit. The third, Geneva Convention, Article 135, one of course. And fourth, Geneva Convention, Article 148. And only because I'm nice to you, I'll add also Article 3 to the 1907 Hague Convention, the fourth Hague Convention. And the first protocol, Article 91, which is again binding international law. And so even given that India has not signed and ratified the first protocol, it is still, to the best of my understanding, binding over India, unless, again, as I said earlier on, you show me a law, a formal and primary law that says the opposite, and then the customary international level of customary international law here doesn't apply automatically as it should when we think about importing, of course, ICTY. And 7, how can you not mention Israel in this, IHL setting? We must mention Israel. It's unfortunately inevitable. I want to mention an interesting case, and that is the Eichmann case. Eichmann, the gentleman Adolf Eichmann, was kidnapped from Argentina, came to Israel, met the court, had its day in court, but then ended up being cremated and his ashes being thrown to the Mediterranean Sea. Just to remind you, to tell you a story of how it ended. It's a fascinating story, piece of case law. I'm not going to go into it. I'm just going to say the following. In 1961, Israel's district court, nothing less but the district court, which is the lower instance out of 3, of course, and you have Court of Appeal and the Supreme, but then the district court has decided a decision that ended up being binding customary international law and
District court is the middle.
law.
Magistrate court is the
Of course, Court of Appeal, of course, Avra district court is the middle one, and magistrate is lower. I'm sorry. And so in Jerusalem, there is a decision that in 1961 started as a national piece of case law legislation, but led eventually to binding customary international law, suggesting that wrongful acts committed by the accused, starting with 1961, led within the state responsibility doctrine in application of the Eichmann case to accuse Germany for its own acts of state, given that henceforth Germany, as a concrete example, but then country or states in broader terms, are now perceived to be responsible for acts of persons, and that is only one more of the sources that I've mentioned. They pretty much refer to the same rationale. This is a national case law, as opposed to what you saw to be a treaty law, you understand. And 8, the ICTY, how can we not mention the conflict in Yugoslavia, another set of cases. The Fungi Nazda, sorry for breaking my teeth here, but that's the name as I understand it, for 1998. And of course, how can you not mention the Tadic case, another gentleman from a Serbian gentleman that we all are familiar with. Serbia was deemed responsible for the behavior of these 2 gentlemen, and that is one more, in this case, international case law, but still one that clarifies that henceforth we perceive state responsibility doctrine within the IHL context to be binding customary international. Again, weakening India's position to argue the opposite. And the 6th and last argument, in reply to your second proposition, is the irrelevancy, as I see it, of the non-intervention rule to India. India might be in a position to argue. I don't think India, I didn't see in the paper India arguing that. If you want to argue elsewhere, India has argued, so please do so, but then see if you can meet this threshold here and see if your argument survive this critique. But then the critique is this. And it's a very quick critique. It's a heavy topic. I'm not going to go into it much in detail, but I want to say the following. The non-intervention rule, which I should add, is not binding customary international law. Neither it is binding treaty law. Okay, it is just a nice, fantastically nice, well-crafted principle that was resoluted in a General Assembly within Resolution 2625 on friendly relation between states, has passed without the vote, which weakens any proposition to argue that that is in any way binding a treaty or customary international law. Whereas the UN Charter is almost universally ratified, and then the idea of friendly relations between states is by and large narrowly interpreted along the years since its adoption, and then we see that statement being said in the Nicaragua case 86 by the ICJ. I left you with the reference, you can use it and read it in detail. And from there on, it is still something that comes time and again into a discussion, and then the same conclusion applies time and again. I might add in brackets, I mentioned it in class when I teach IHL, but also just public international law, that there is even more to say when it deals with friendly relations between states in comparison or in conflict of laws with specific laws of armed conflicts, as opposed to any type of international law. When we deal with the laws of armed conflicts, there's already within Nicaragua understanding that you want to be very narrow about the way you interpret the General Assembly 2625 resolution. I need to finish. So I'll say, do I have one more sentence for each? I'm going to be fair and square one sentence each. So we discussed these two propositions, which I suggested. One to totally rebut it, that is that India is neither in peace or in a declared armed conflict. I explained why it's wrong, why I think it is simply wrong. Your second proposition that actually applies more as a question of fact as opposed to a combination of law and fact. Here I made 6 arguments in critique. I think you should solidify your argument here, which leaves us with the 2 remaining arguments, which I'm not going to relate to. I knew that I'm going to have so much time, so I left it as a commitment to be sent by email, as you can see. Your third argument, a sentence each, as I said, is that we do not have a distinct armed conflict identification within IHL, within public international. That is totally wrong, totally wrong. I refer to a case you mentioned 3 times in the paper, but not in the right place. The place you should have mentioned, start and end the discussion, is paragraph 70. Write it down. Paragraph 70 of that, which is exactly where, from there on, 1999, henceforth, we perceive IHL to be actually defined quite well, starting with not non-IHL international, of course, conflicts, all the way to international conflicts, given that Serbian conflict in Yugoslavia was a non-international, then it was widened to the international as well as the non-international conflicts. Paragraph 70 is the reply to you. It is a fantastic explanation to how intensity and the level of organization explain, detail, specify well enough what is an armed conflict. I think you should erase my case on that point. And the fourth proposition, again, I think is a problematic one, is that we have a lack of binding treaty or customer or customer international law vis-a-vis the secondary question of what type of armed conflict is it. Again, that is not true. If you want to follow on that, I would be delighted to help. There's a lot to say here, as some of us, I'm assuming, know. Then that's an argument you want to actually take out of your paper. Methodology, sentence. No, okay, so I'll leave it here. A couple of ideas about methodology, which will be better.
Thank you.